minutes in our first rounds, and I will begin that round of questioning for us, and I will begin my 6 minutes now, and colleagues are welcome to keep me on time as well. Thank you. Thank you very much again for both being here today and being forthcoming with that information, your opening remarks, Mr. Deputy Minister. You're aware that the Mass Casualty Commission has a public interest mandate to investigate the worst mass murder in Canadian history to get answers for the public, correct? The Department of Justice also has the obligation to assist the Commission in achieving its mandate to serve the public interest, correct?
Agreed.
You're aware that Chief Superintendent Chris Leather recently testified that at the Commission inquiry that he received legal counsel from the Department of Justice, your department, to withhold evidence from the Commission unless specifically asked. That is, your department, the lawyers in your department, the counsel, told him to provide evidence reactively and not proactively. Is that correct?
That is correct, but only with respect to the, I guess what's referred to now as this wellness report. So I have three reasons, really, to explain why I think Chief Superintendent Leather misunderstood the advice that he received. First, we learned of this, I guess our council met with Chief Superintendent Leather on July 5th, and it was during that meeting that we learned of the existence of this wellness report for the first time. It was, from what I understand, a report that was commissioned a year after the events. What we counseled Chief Superintendent Leather to do was, because we hadn't seen the report yet, we didn't know to the extent to which it was relevant, if all of it was relevant, portions of it were relevant. It was obviously prepared for a different purpose. And so our advice to him was, don't raise it proactively, but if it comes up, answer the questions. That was the advice we gave to him. We gave no advice with respect to being reactive or not being proactive with respect to two other pieces of information. One was about the April 28th meeting, because that information was already before the Commission, and we like all witnesses, we told them to be very
Thank you, sir. So just to be clear, you're saying that there was another one. We've been hearing a lot of these misunderstandings, as I'm sure you are aware, during this investigation. So you're saying that Superintendent Leather misunderstood, but that in fact your department did advise him to be reactive and not proactive, but it was specifically in terms of this wellness study that was being undertaken for Nova Scotia RCMP. But he was under the impression that that reactive approach was to be taken at large whenever he was asked questions by the Commission or otherwise. So it's odd that that misunderstanding is quite significant, I would say, and he shared that at the Commission. So are you aware then that the Honourable Thomas Cromwell, Council Director of the Commission, wrote to Department Lawyer Laurie Ward? I'm just going to pause. Can we ensure we're all muted? Thank you very much. I'm going to resume my time. Thank you. You're aware of this letter sent to the Department of Justice on August 6th from the Honourable Thomas Cromwell, Commission Council Director. He was not familiar that this was a misunderstanding. He is under the impression that your department, in fact, asked Mr. Leather to be reactive in his testimony. Are you aware of this letter that I'm referring to?
Letter says is that he is concerned to have heard of Chief Superintendent Leather's testimony and is asking us to confirm whether that's correct or not correct. And we have responded to that letter. Laurie Ward did respond to that letter on August 9th to explain what I just explained to you a minute ago.
Have you advised anybody else to be reactive in their approach to the wellness report or the Commission generally, anyone involved in this case in the RCMP or otherwise?
No, this was a comment we made to Superintendent Leather because it came up when we were preparing him, or our council were preparing him for an interview with the Commission Council the very next day. So he brought it up at the prep, and we had never seen this report. So it's reasonable for us to say, well, before we'd like to see it and give you some advice before before you raise it. But if questions come up, you have to answer the questions.
Thank you, Mr. Deputy Minister. So to be clear, you have not advised anyone to be only reactive and not proactive.
No, and with every witness before the inquiry, we have counseled them to be truthful and to assist
so
the Commission as much as possible. So at any
time since the 2020 Nova Scotia mass murder, was the department concerned about political interference from government? At any time did you advise anyone about political interference?
No, as I said in my opening remarks, we were not involved, or nobody sought legal advice on this April 28th meeting with respect to the disclosure of firearms information.
Thank you. And have you provided, so you have not provided any legal advice to the Prime Minister's office, the Public Safety Minister's office, or any other ministerial office concerning the mass casualty?
Well, we've provided lots of advice
Okay.
to the government, but I think the allegations are with respect to the firearms information at this April 28th press conference and the subsequent meeting with the Commissioner.
So you've
We have
provided
not
no
provided
advice?
any advice with respect to those.
Justice Canada spokesperson Ian McLeod said that the final 4 pages of Chief Superintendent Campbell's notes were withheld until the end of May of this year because they, quote, required further assessment of whether they were privileged or very aware of this. What aspect of their content merited that further assessment that took that additional 3 months to release Mr. Campbell's notes? Again, you'll remember it's those 4 key pages that have really initiated this entire investigation.
And I've said earlier, those 4 pages were caught up in another group of 35. There were 35 pages altogether that we'd flagged. We flagged things for further review. Some things are legal advice. That's easy to spot. Some things may be cabinet confidence. Some may be public interest privilege. And depending on the nature of the privilege, our counsel have to consult other people. So it takes time to review them, especially since they're handwritten, and sometimes we have to go back to our clients to understand the context within which those comments were made. So the privilege review
time is
does
up.
take some time.
Great, thank you. Our time is up.